try to do that, and you can try not to breed, etc. Anyway, this unenclosable object is constantly reproducing genes. And I argue that this is an example, just as clear to me as radio spectra, of a commons by necessity. And it isn't a pragmatic argument. Okay, so this is distinct from anti-commons argument. When you think of commons, you think of the because a lot of you, Lawrence Lessig and people like that speak of the anti-commons effect. That's a pragmatic argument, right? That is not what I'm making. I'm making an ontological argument. I'm talking about the nature of the thing itself. So when people try to patent genes, when they do what Craig Venter and others have done in trying to patent genes, they are attempting to enclose an unenclosable space to the exclusion of others. And I argue that this is an ethical wrong. But where does that, I'll give you an example. So we have people from the ACLU here today as well who are courageously suing Myriad Corporation for Myriad's patents on the BRCA1 and 2 genes. And let me introduce them, because I really think they're doing great work. I saw Sandra too, right? Okay. Sandra Park is with the ACLU. She's an attorney on the case that is against Myriad. And Tanya Simoncelli is a lead scientist on this case. So they are doing the right thing here because Myriad has violated not only the law, I mean, they're doing something that I approve of ethically as well, because there is an ethical problem. Myriad has attempted to possess, through patents, the BRCA1 and 2 genes, which are responsible for a great number of cancers. And in so doing, they are trying to prevent others from using those genes. So they have actually sent cease and desist letters to researchers who were doing research on the BRCA1 and 2 genes, who were, in the course of that research, reproducing the genes. All right? I argue that not only is that illegal, which is Luigi's domain and Sandra's and Tanya's domain, it is unethical, because this is an attempt to curtail our autonomy over our own genome. You and I have as much right to investigate what makes us up as anyone else. And this goes back to the axioms I explored early on in the talk. What Myriad owns through these patents is a right to exclude you from finding out about what is in you. And they're exercising that right to our common detriment. In fact, it does violence to you when they exercise that right, in much the same way as if Peter ripped this book from my hand. So, our fourth premise. And this now goes beyond the gene argument and goes into new territory for me, so be gentle. IP rights are exclusionary rights that prevent the unauthorized expression of protected idea types. So I realized after I made this argument that the two books I've talked about so far lead me to a conclusion that I didn't realize I was going to end up having to accept, but which I now accept wholeheartedly. When an author or inventor owns their intellectual property, they can exclude others from making unauthorized reproductions of their expressions. They can receive royalties for any reproduction made, and they can enjoin the expression, and can prevent the expression by others of that idea type. Okay? That's basic intellectual property law. Now, we allow for all sorts of restrictions on our expressions, right? Consistent with Mill's liberty principle. And what was that again? Where that expression injures another, does some injury. So typically, when the law says you can't make a certain expression, it has to do with preventing a physical harm or incitement to some physical harm. And I've come to the conclusion that all intellectual property law is some form of government restriction on expression having nothing to do with physical harms or incitement. And in fact, all expressed ideas belong to the category of commons by necessity, as there is no meaningful way of possessing or enclosing them. Okay? So besides the ethical problems of governmentally curtailing free expression, I say that intellectual property law as a category of law is an attempt to enclose a commons by necessity, just like laws that allow for the patenting of genes. IP rights prevent the free use of expressed ideas, which are commons by necessity just as much as radio waves are, just as much as the element oxygen is, genes and laws of nature. And IP laws do, in general, what gene patents do. They prevent you from using something that is a commons by necessity. And if the positive law violates something grounded, as I've argued before, then it is unjust. And so my conclusion is that our shared rights to commons by necessity are grounded in the brute facts of their unenclosability, and attempts to curtail our access to that commons by necessity are similarly unjust. So, you know, there's this old aphorism that ideas want to be free, but that's a little too glib. They are. Once they are expressed, once they are made manifest into the world, expressions are simply free. And attempts to enclose them are morally wrong, as attempts to enclose genes, sunlight, oxygen, or other commons by necessity are. And so that is my radical conclusion. I didn't expect to reach it when I started investigating intellectual property law about 12 or 13 years ago. But that's where my work has taken me. And I would ask you to consider, for instance, there's a ton of examples we can talk about. Perhaps this is fodder for our discussion now. But I want to thank you for listening to me.